Parliament's Rules Subcommittee will today continue its meeting to deliberate on a draft procedure for implementing Section 89 of the Constitution, which deals with the removal of a president. This follows a Constitutional Court judgment handed down on the 29th of December that the National Assembly had failed to put in place proper rules regulating a procedure for Section 89 of the Constitution. This after President Jacob Zuma was found to have failed to uphold the Constitution regarding non-security upgrades at his home in Nkandla. The court ordered Parliament to do so without delay. To understand why this meeting is so significant in terms of the Constitution, we're joined by Phephelaphi Dube, Director at the Centre for Constitutional Rights in our Cape Town studios. Phephelaphi, thank you. Thanks very much for being with us here on Morning Live.
Good morning, thank you.
The previous motions of no confidence on the president have failed. We've all watched, we've all seen this happen. How is impeachment different to a motion of no confidence in the president?
Well, the first thing that we need to understand about the basic difference between an impeachment or a removal of the president as well as a motion of no confidence is that, first of all, the impeachment process is really a matter of fact. And it's a matter of fact that has to be proved according to three grounds. The first being whether the president has violated the Constitution or the law in a serious manner. The second being whether there's been some form of serious misconduct. And the third being the inability to perform the functions of the office. That inability arising perhaps from illness or for whatever reason that would make the president unable to perform his functions. But nonetheless, the entire process is punitive and it's reached by a 2/3 majority. And because of its punitive nature, it means that if the motion is successful, then the president would have to leave the office and he wouldn't enjoy any of those benefits that come with the office. So he would lose his pension, for example, he would lose, access to state security. Now, a motion of no confidence, on the other hand, is really a matter of opinion. So there again, you need to juxtapose that with the impeachment process, which is a matter of fact. So it's a matter of opinion based on, just the whims of the members of the National Assembly. And the another important difference is that a motion of no confidence is reached by a simple majority. So that would be 51% of the 400 members of the National Assembly. And not just that, but it removes the president, the deputy president, as well as the cabinet ministers. So that in a nutshell is the difference between the two processes.
So we see, and from my understanding, and perhaps please correct me if I'm wrong, the South African Constitution doesn't actually use the word impeachment. If I've got this right, the Section 89 of the Constitution describes a mechanism similar to what impeachment actually is, but it doesn't use that word impeachment. So now the Constitutional Court is saying that they must adopt this issue with a 2/3 majority to be put into the Constitution. Is this correct?
Yes, absolutely. In fact, the heading of the section that deals with that process is called removal of the president.
Yeah.
But as we've seen in the past, we didn't really have a sort of mechanism that would determine whether or not the president is indeed guilty of any kind of serious misconduct. And that was really the thrust of the case before the Constitutional Court. The fact that there didn't seem to be any processes within the National Assembly, at least a process that would determine the extent to which the president is guilty of some kind of serious misconduct. And of course, the interesting thing about the various judgments, there were 4 judgments in total that came out of the court. But the interesting thing really was about the different judgments was the debate about whether or not the notion of a serious misconduct is a value-laden judgment, or whether one should simply accept what a court arrives at without the National Assembly second-guessing what a court has arrived at. But of course, as we saw from the majority judgment, the final agreement by the judges of the Constitutional Court is that right now, the National Assembly doesn't appear to have a process that would determine the extent of the serious misconduct or the serious violation of the law.
We're hearing the Constitutional Court is instructing Parliament to set out these impeachment rules, but in effect, who has the power to impeach a president?
Yes, this question ultimately touches on the notion of separation of powers, and there have been debates in the public discourse about whether there was some kind of judicial overreach. But I would venture an opinion that I think the majority judgment in particular was very careful about not transgressing that thin line. And ultimately, the majority judgment simply told Parliament what to do, but it did not tell Parliament how to do its job. So I think that's where the nub of the matter lies. But to answer your question, ultimately, in terms of the Constitution, and this is a point that the majority judgment makes, in terms of the Constitution, it's really only the members of the National Assembly who should be voting, who can vote in terms and determine whether or not the president should be removed from his office. And that's the point that the judgment makes very clear, that the courts do not have that kind of power.
As it stands right now, when we talk about that removal of a president, the Section 89, the three possible grounds for the removal of a president are a serious violation of the Constitution or the law, serious misconduct, or inability to perform functions of the office. Will the guidelines for impeachment be exactly the same? I mean, are those going to remain in place, or will we see changes?
Well, obviously the Constitution provides a framework for the rules, so it would be very difficult for members of Parliament to deviate from that particular framework. But of course, bearing in mind that the National Assembly is its own independent body that's really only subject to the Constitution and the law, the National Assembly is well within its rights to perhaps elaborate on those rules and to perhaps create other grounds. But of course, ultimately, whatever the National Assembly's rules arrive at, it obviously has to meet the constitutional test.
I mean, when we talk about previous countries and other countries that we're looking at in terms of impeachment, we do know that just recently, I mean, Brazil's Dilma Rousseff was impeached as the president there. 1998, former US President Bill Clinton was impeached for perjury. It's something that we've seen other countries doing. It's never been done here in South Africa, however. And I believe that we are looking at international laws and how impeachment works in other countries.
Yes, absolutely. And the interesting thing is that in the oral arguments before the Constitutional Court, the EFF Council had actually made the point that he had specifically focused on Brazil, the fact that Brazil had a procedure in terms of which the National Committee of Brazil's equivalent of the National Assembly would meet prior to the vote to determine beyond a reasonable doubt that indeed there had been a serious violation of the law. And then based on that fact, then the members of Parliament would be logically expected to vote in a certain way. So it does appear that, South Africa is obviously following international best practice. And in that sense, we're very much bringing our laws, we're bringing our legal practices to be in line with other countries. And I think in a sense, it's very much about, deepening South Africa's democracy, in that we're once again finding ways of ensuring that the National Assembly continues to hold the executive and the president as the head of the executive accountable in line with the constitutional mandate of the National Assembly.
Well, if anything's come out of this, we've found some loopholes that are going to be closed due to this. And thanks so much. We look forward to finding out how this all ends. And I know that many people are saying that this should be wrapped up and in place by March this year. So it's yet to be seen on that one. But we thank you very, very much for talking to us here on the program about impeachment. That's Phephelaphi Dube, Director, the Centre for Constitutional Rights. It is 7 o'clock.